Joe Rogway. I'm going to be the moderator of tonight's event, and I'd like to welcome you to the 2010 Sonoma County District Attorney Candidates Debate on therapeutic cannabis. What we're going to do is start off with a little introduction and explain the process. First, what we're going to do is flip a coin to see which candidate goes first. Then the candidates are going to give alternating responses, and what we're asking is due to some of the vitriol, some of the commentary that has gone on in this race previously, we just asked the candidates to keep this somewhat proactive, somewhat positive, and discussing the subject at hand and refrain from any of the issues that were in previous debates. That's to say, focus on the questions. The questions will consist of 6 previously determined questions that were given to the candidates ahead of time. That will take us through till about 8 p.m. tonight. Each candidate will give about 3 minutes to respond, and we have Kamari here, who is walking there in the yellow from Sonoma Alliance for Medical Marijuana. She is going to be giving the time. So at 30 seconds, and 30 seconds is blue sheet of paper. Time is up, that's a red sheet of paper, just so the candidates know. After that, there will be questions from the audience. And what we're going to do is we're going to have attendants situated on either side of the auditorium here. You can see them holding up the note cards. And if at any point during the event anyone wants to ask a question, simply raise your hand, an attendant will come by, give you those cards. And then when you have finished completing the card and you have a question you want to ask later on, raise your hand again with the card in it, they'll come by and pick it up. All questions will be addressed to both candidates, so there'll be an equal opportunity for responses for the questions. And for those audience originated questions, each candidate will get 2 minutes to respond to those. The hosts for tonight's event are the Sonoma Alliance for Medical Marijuana and the Sonoma County Chapter for Americans for Safe Access. They put this on tonight. Sponsors of the event include Peace in Medicine, Organican, and the Cannabis Law Institute, all local Sonoma County organizations. Oh, and Sonoma Patient Group, I apologize. Joining us tonight are the 2 candidates for Sonoma County District Attorney. On my left is the incumbent current District Attorney of Sonoma County, Stephan Passalacqua. To my right is the challenger current Chief Deputy, Mendocino County District Attorney's Office, Jill Ravitch. So what I'm going to do is the coin flip now. Who wants to call it?
We'll let the incumbent call it.
The incumbent wants to call it?
I'll let you call it, Joe. You call it, Joe.
I'm not playing. I'm just the moderator.
How about a person from the audience like Paul Payne?
Heads. Heads? Okay.
Wait,
what does heads mean?
Yeah.
Okay, for the record, heads means Mr. Passalacqua goes first. All right. Heads it is. Heads it is. Okay. Thank you. It actually isn't my quarter. Okay, so the first question for Mr. Passalacqua. These are the introductions, and incidentally, on each of your agendas, you can find printed on the back of the agenda the questions, so you can follow along, and there's no surprises here. First, what we want to know really is who are you? Why are you running for District Attorney? And do you know anybody who has benefited from the medical use of cannabis? I'll start with those.
First of all, I want to thank Sam and Americans for Safe Access for hosting this forum tonight. I think it's very important forum in our community, especially medical marijuana. But first I want to tell you a little bit about my background. I was born and raised in Hillsburg. It's up the road north about 14 miles, if some of you don't know that. But I'm from a large family, youngest of 7 kids, and my parents instilled in me a strong work ethic and a respect for seniors, and bless you back there, and also really a respect for keeping your word. And my old man, who's up above looking down here tonight, told me your word is your bond. And that's something that was instilled in me as a kid, and I've carried with me as throughout my education and throughout my role as your district attorney. I was elected twice by the voters to be your district attorney, and I'm very humble and appreciative because I feel this is the most important job in this county, ensuring public safety. And I promised on 2 separate occasions that I would do everything I could do to make this a safe community. I would build a top-notch DA's office, strengthen crime prevention programs, and make sure the voice of victims was heard loudly and clearly. And I've kept those promises. And when I ran in 2002 and 2006, I met a number of you here in this room at different forums. And I promised you at that time that we would be fair and compassionate to qualified patients of medical marijuana. Medical marijuana, in my opinion, is a public health issue. I've always felt that that is something that we should be serious about. It should be a safe access. It should be a safe environment. And I've strived to ensure that we do that here in Sonoma County. I'm proud of my record, not only of going after violent gang members and sexual predators, but I'm proud of my record of keeping my word to the citizens of Sonoma County. During my tenure, we have not had one jury trial for medical marijuana. Sure, we have filed charges, but after legitimate information came forward that it was for medical marijuana use, we resolved those cases in a fair, compassionate manner. There are people in this room tonight that I know since I was a kid who used medical marijuana, who used it for their illnesses of cancer. I have close friends, a close friend who passed away from melanoma, who had a medical marijuana card. So I know firsthand that medical marijuana works. It's something that is the law in California, and I will continue to exercise my authority as district attorney in a compassionate way to protect individuals who are qualified to use marijuana and make sure that our community is safe. I have strong support in this community. The Attorney General has endorsed me, Jerry Brown, former San Francisco District Attorney Terrence Hallinan, current San Francisco and District Attorney Kamala Harris, Alameda County District Attorney Nancy O'Malley. Both of those individuals were colleagues of my opponent at one time. And I have the Sonoma County Law Enforcement Association. I would be honored to have your support in this upcoming election. It's hard to believe it's going to be here in a little over a month. But it's a privilege to be here tonight, and I'm honored to be your district attorney. Thank you.
Ms. Ravitch, same question.
Thank you. Good evening. I would also like to thank the sponsors of tonight's forum for providing us an opportunity to talk to you about medicinal marijuana and what our positions are with regard to enforcement of the laws and protection of qualified patients here in Sonoma County. I remember being here about 4 years ago, and I think a number of you in the room were here as well. And I'm hopeful that the discussion we have tonight will be as informative for me as the discussion was 4 years ago. I learned a lot during the course of answering questions and listening to questions and then talking with members afterwards, and I hope we'll continue to do that tonight. I've been a trial lawyer for 22 years, and some of you may know me from my almost 15 years in Sonoma County as a prosecutor. I went to law school to be a prosecutor, and I'm not going to go into great length about my background. There's a flyer over there to my right if anybody wants to pick one up and have a look, and we have a website so you can get more information. I'm happy to talk to you. But the crux of the matter is I'm a career prosecutor, and I will tell you I've spent most of my career in the courtroom, completing over 100 jury trials, including 12 murder cases. I have a substantial experience in the courtroom, and I think that's what brings me to this point where I'm ready to lead an office full of prosecutors. It's important that the prosecutors that represent you understand what the job is so that we can ensure that public safety exists here in Sonoma County. The priorities need to be on effective prosecution. They need to be on working well with our law enforcement partners to ensure that your rights are protected, to ensure that the guilty are held accountable, the innocent are protected, and to ensure at the end of the day we all feel safe about where we live. I'll talk a little bit more about my endorsements later, but as many of you know, most of the law enforcement community has come out to endorse me. And most of the law enforcement community was endorsing my opponent when I was here 4 years ago. Additionally, I have the support of Supervisor Shirley Zane, Senator Mark Leno, State Senator Mark Leno, the entire Santa Rosa City Council, and a number of individuals in this room. With regard to my familiarity with medicinal marijuana, I want to be really clear with you. Most of my career has been spent prosecuting other kinds of cases. I actually never held an assignment as a narcotics prosecutor. It was an assignment that I just wasn't very interested in as I developed my career. I've become more familiar with issues surrounding marijuana since I went up to Mendocino County, where I've been the chief deputy for the last 2 years. But again, I didn't really delve into the actual prosecution, as at least one attorney who's here today can verify. She and I haven't really dealt much with each other on these matters. I will tell you, in the last few days, I've really been honing in on my understanding of the medical cannabis laws and the ambiguity in those laws. And I've been fortunate enough to talk to not only the sheriff, but other members of law enforcement here in the community, defense attorneys. In fact, I spent some time with a couple before I came here tonight, individuals who are patients, as well as advocates for medical cannabis patients. And I have to tell you, it's all very confusing, but what is most important is that we ensure there be safe access to medical cannabis for qualified patients. It's the law. And the job of the district attorney is to enforce the law and to ensure that those that are following the law are allowed to do so. So I'm looking forward to talking about the state of the law as we go through these questions this evening and talking to you a little bit about what my philosophy is. But at the end of the day, I hope when we leave here at the end of the evening, you'll understand that I really do support safe access to medical cannabis. I always have. I said as much when I was here 4 years ago. I'm lucky enough not to have any family members who have been in a position where they've needed something like that to assist them, but I've met many, many people and heard many, many stories, including meeting a gentleman in the back of the room tonight whose son suffers from seizures and uses medical cannabis. I understand there is a place for it, and I understand the law requires that we ensure there be safe access in our community. So thank you very much for coming out to hear us tonight.
And the next question goes back to you, Jill. Recently, in a unanimous decision, the Supreme Court of California held that the guidelines under Health and Safety Code Section 11362.77, which clarifies or did clarify the amounts of medical cannabis that a patient or other lawful person could possess or cultivate, those guidelines were essentially tossed out. However, the Supreme Court did say that those people who were within the guidelines would be immune from prosecution, arrest, or criminal sanction. The Sonoma County ordinance, which permits 3 pounds of processed marijuana as well as a canopy of 100 square feet and 30 plants, is based on 11362.77. My question for you is, will your administration guarantee immunity from arrest for those authorized persons within Sonoma County pursuant to those guidelines?
Joe and I used to work together in Mendocino County, so it's kind of fun to be down here in Sonoma.
I was a public defender up there.
He was. We didn't work together. We didn't work together. Well, we did. We worked together to keep the system honest. How many of you have read the Kelly decision? This is a very well-educated audience. I mean, a number of you are raising your hands. It was a lengthy opinion. Thank you. It was a lengthy opinion. It came down, I think, in January of this year. It was long awaited. And for those of you who haven't had the opportunity to read the opinion, if you're going to do it with a strong cup of coffee. It's a lengthy, lengthy opinion. And as Joe pointed out, it basically did away with the limitations that had been imposed because it violated the will of the people when they enacted the law for medical cannabis. And basically what the case says is it's on a case-by-case basis now. What's important is what's reasonably necessary for an individual patient. And as a result of the Kelly case, I think things are kind of up in the air now. And this is what I've found through talking to a number of individuals who I just mentioned, prosecutors, I've talked to law enforcement, defense attorneys, advocates, and Bill Cogbill. Now, Sonoma County is unique because it's been addressing this issue for a number of years, and everybody came to the table and after lengthy discourse and research decided that the 3-pound, 30-plant, 100-foot canopy seemed to work for most patients. You could always go away from that if there was an unusual need that could be verified by your physician. Well, I talked to Bill Cogbill earlier today, and he still wants to use those guidelines. He's met with the other chiefs, and he's actually drafting guidelines right now that he wants to use. I talked to narcotics officers who are actually imposing those guidelines right now. So that if you work within the guidelines, the chances are, at least as far as the county goes, you're going to be immune from arrest. I can't promise anything to you if I am honored with your vote and am elected your next district attorney. I can promise you that I will be fair, that I will follow the law, and that I will work as well as I can with law enforcement as well as you to make sure that we understand what the rules are. It certainly makes sense to have guidelines that we can all follow so we can decide exactly how to go about carefully processing and cultivating medical cannabis so that the patients can be served. That's what it's all about at the end of the day. Everybody just wants to do the right thing. So I was really happy to hear that Sheriff Cogbill is working on those guidelines. They seem to make sense to me, and it would appear that that's the direction that we're going to be going with regard to this county. Now, bear in mind, there will always be variances. If there are weapons involved, if there are other aspects involved, such as excessive use of PG&E, things like that, if there are children that are endangered, it will still be a case-by-case basis, but we'll begin with a presumption that if you're within the guidelines, you're okay, as long as you have evidence that you are not authorized, but you're a validated patient. And I was really impressed talking with everybody today because Sonoma County is so enlightened. It really is. Mendocino County is still fighting like cats and dogs up there, and they're working hard to come up with good guidelines. They haven't reached them yet. But it seems to me that Sonoma County is really ahead of the curve, and it seems that those who are not involved in the use and cultivation of medical cannabis are supportive of these efforts as well. So I think we should applaud the efforts of our advocates as well as law enforcement for coming together. And I can promise you that I will continue the discussion because we have to be on the same page as we move forward. Thank you.
Stephen, same question.
Well, I was pleased to hear the final remarks of my opponent. She says Sonoma County is very enlightened and we're doing a great job. I'm not sure, Jill, is that an endorsement for me? Really, Sonoma County has been in the forefront and been very proactive in this arena because we really, I think, care about what happens to qualified patients. And also we want to make sure that the illegal activity associated with marijuana diminishes. We have seen sometimes in this county and other counties the unfortunate crime that goes along with growing marijuana in an unsafe place and in not a regulated arena, if you will. But with respect to the Kelly decision, it made it very clear that the definition is reasonableness. What is reasonable for a qualified patient? It did find constitutional the patient ID program, the state patient ID program pursuant to SB 420. And I think that's a good thing because I think that from my vantage point, the ID card or recommendation gives some how should I say it, shed some further light in assisting law enforcement and assisting some of the caregiver providers and things along those lines. But Sonoma County still uses as one of the factors the guidelines that we've had for a number of years, the guidelines that were put together by the Board of Supervisors, and there was really extensive meetings with Doc Knapp, with Mary Pat Jacobs, with experts in the medical marijuana field, experts in the law enforcement field to have a discussion of what was fair and what would be something that we all could live with, as well as keep in mind that we want to prevent the criminal element in this arena. So from that perspective, I'm pleased with the status here in Sonoma County. And I would point out what my opponent just said, that hasn't been the case in Mendocino County. There have been some issues up there. There have been some trials up there on these issues during her tenure up there. But here in Sonoma County, law enforcement continues to use these guidelines as a significant factor. My office does, and I think that's a good thing to provide some consistency. I think it's important in this arena that you have consistency, that the patients know what law enforcement's going to do. Now, I've heard in some occasions that law enforcement has not necessarily, well, I'm trying to think of the word, helicopters make a little noise. In terms of, there have been some times where they've pulled out the plants when maybe there was some justification for growing, but there wasn't the appropriate documentation. So that's an issue that we need to streamline. We need to have a meeting with different policymakers and try to address that in an effective manner. The other thing I would just say is that from different people that I've spoke to in the medical marijuana community, Sonoma County, I've been informed that Sonoma County has the most reasonable and fairest guidelines in the state in terms of how we work with caregivers, how we work with qualified patients. As your district attorney, that practice will continue during my third term if the voters see so fit that they feel I've been doing the job. And I have a proven record of being fair. I'm not going to give lip service. You can judge me not by my words, but by my action these past 8 years in terms of being fair and compassionate to qualified patients of medical marijuana.
Thank you. And just to follow up real quick, to clarify, will your administration guarantee immunity from arrest for those authorized within the guidelines?
Is that for me first? Or?
Yes, yes.
Well, I think, there's different standards in terms of what an arrest is and what we can do in terms of prevailing at trial. And the law enforcement community, the sheriff, the chief of police, they have their authority, what they think is appropriate for an arrest. They have discretion, just like we have sole discretion on determining what charges are filed, if any, at all. So that's a complex question, and obviously we can decide that we're not going to file charges, and there's been cases where we haven't filed charges, but law enforcement may have made an arrest, they may have pulled up the plants, and I think the return of property issue is a question that we'll address later on as well.
Thank you. And Jill, just to follow up, your administration, will they guarantee immunity for those within the guidelines?
I kind of answered it a little bit, I think, when I spoke earlier. I don't think that the district attorney can guarantee immunity from arrest. That's not within the province of the district attorney's office. The district attorney's office determines whether or not to file charges and how to pursue once that determination is made. So I think the immunity from arrest really is a question for the sheriff and other law enforcement officials. I will tell you that in my conversation with Sheriff Cogbill this afternoon, the policy that he's drafting appears to indicate that that is going to be the policy in this county.
Thank you. Thank you. Next question to you, Mr. Passalacqua. It has to do with collectives and cooperatives. First, I would like for you to state your definition, or how would you define a lawful medical cannabis collective? And second, if elected, what guidelines would your office utilize when instructing members of law enforcement and members of your office as to the lawfulness of collectives?
Well, as the district attorney, we're already using guidelines from the Attorney General's office. Attorney General Jerry Brown, who has endorsed my efforts for a third term, has laid out guidelines. As everyone knows, I think the cooperative process, a particular business has to have articles of incorporation. They have to file that with the state, or they can go through that's the corporation code or the food and agricultural code, but it has to conduct its business for the benefit of the members, and it has to provide security and structure, just like agriculture cooperatives that provide various local products for their members. So it is pretty straightforward in terms of what is required according to the Attorney General guidelines. And I believe, did you also ask collectives too, Joe?
Yes, yes.
Yeah.
Actually, collectives is primary.
Right.
Yeah.
Okay, and as to collectives, the law, unfortunately, does not define that. The California law does not define that. So we have to look at what common practice is in the community, in different communities throughout the state. It's basically a business that is jointly owned by members of a group. The guidelines say that it medical marijuana should be sold to its members only. There should be a list of qualified patients or that do purchase medical marijuana from a collective. And those are the type of things that sometimes can get a little gray still, because a lot of this has to do with planning, planning departments, zoning, and a lot of other factors from city and county authorities that can affect where a particular collective or cooperative is. And then obviously, I guess the unknown still is the DEA, and as well as the federal government, because on the federal law, marijuana is still considered a controlled substance, and the DEA continues to do raids throughout the state. We have not cooperated in any of that type of scenario here in Sonoma County. We're very fortunate that we're not Los Angeles, where that has happened on a regular basis. It's happened in San Diego, where these type of entities have grown. In fact, in LA, the city of LA, there's more of these type of businesses than Starbucks. In 2005, there were 4 storefront businesses in the fashion that I discussed. Today, there's close to 1,000 or applications that are pending that make it quite an extensive number. But we don't have that type of those numbers in Sonoma County. We do have a few that are operating lawfully, and we have not been involved in any prosecution of those particular entities or storefront businesses.
Thank you. Jill, same question.
Well, I know it's going to be unusual to hear this, but I kind of agree with some of the definitions that were just given by my opponent. He essentially stated what the Attorney General's opinion is. It's not binding, but it is an opinion that counties can look upon so that there can be uniformity throughout the state with regard to the definition of collectives and cooperatives. I think I'd like to read a section of it because it's something that I think is a statement that we should all abide by. It says, any group that is collectively or cooperatively cultivating and distributing marijuana for medical purposes should be organized and operated in a manner that ensures the safety of the crop and safeguards against diversion for non-medical purposes. I think well-regulated and safety are the key words here. Whether or not it's a collective or a cooperative, it's important that the patients have safe access and that the establishment is set up in a way that comports with the guidelines, vague as they are laid out by the Attorney General. This is an area of the law that is really vague. And again, we're always going to butt up against whatever the federal authorities decide to do with regard to dispensaries. So I think what's really important for us as a community is to continue to have dialogue and continue to understand everybody's position and everybody's concerns about the establishment of these collectives and cooperatives so that we can resolve matters at the table before we bring these issues into court. As we all know, there's a case now that just resulted in a preliminary injunction from Judge Boyd, and that's a case that is going to continue to work its way through the system and is going to have a big impact on how things are handled here in Sonoma County. But the most important thing to me, if I'm elected as your district attorney, is that those of you that are in the room who are obviously advocates of and patients of cannabis, medical cannabis, continue the dialogue with law enforcement members, including myself, so that we can all understand where we stand and work together to ensure that there's safe access to cannabis. I think this is sort of cutting-edge law that we're dealing with here as people begin to grow into more and more acceptance of the valid use of cannabis for medical patients. I mean, we're beginning to see more and more literature coming out talking about the positive effects of cannabis. It used to be we just talked about it as helping with appetite issues and things of that nature, and now we're starting to read more and more anecdotal material about what it can do. So collectives, loosely formed, cooperatives, a little more defined with regard to articles of incorporations and things of that nature. There still will be a gray area with regard to the involvement of the patients because it's always made up of patients. And I think that's the area where we need to come to the table and have the conversation. Thank you.
Thank you. And the next question goes back to you, Ms. Ravitch. And this one has to do with prosecution rates of medical cannabis. In both jurisdictions in which each candidate is currently serving, that being Sonoma County and Mendocino County, respectively, there has been an increase in cannabis prosecution rates. I'm seeing a statistic right now that in Sonoma County, there's been a 130% increase since 1995, as well as 75% in Mendocino County. What guidelines will you give your administration as to selecting and prosecuting medical cannabis cases, first? And second, how will you ensure that law enforcement officials are consistent with your administration's guidelines?
It was noted earlier that Mendocino County has been prosecuting medical cannabis cases. I want to begin by reminding everybody, I'm not the district attorney of Mendocino County. I'm third in command there. I'm the chief deputy. I do supervise the trial attorneys, but I don't make the policy in Mendocino County. Mendocino County is a different place than Sonoma with regard to a number of law enforcement issues. I give my best advice, but at the end of the day, I don't get to make the final decision on policy. That being said, I do think that we need to have a good approach with regard to law enforcement. I think that it's important that we understand that there are those that are abusing our laws. I mean, there are those that are not qualified patients and are taking advantage of the situation. It's just the way the world is. And what's important to me is that those individuals do not disabuse what authorized and authentic patients are entitled to, so that not only the public begins to look with disfavor upon qualified patients, but also that safe access is in some way endangered. If I come upon cases where there is violence, where there is a risk of violence, where firearms are involved, where there's theft of PG&E, things of that nature, obviously we're going to be looking at forceful prosecution. What I've been telling people, and I think I've been telling people that since I was here 4 years ago, the prosecution of marijuana cases, in my opinion, should be at the lowest of levels. I think we have more important criminal activity to use our limited resources in enforcing. We need to work on violent crime, we need to work on gang crime, we need to work on domestic violence. So I can promise you that if I am elected, marijuana prosecution is going to be at the lowest level unless there is evidence of environmental damage, unless there is evidence of violence, unless there is evidence of significant sales and profiteering by cartels, things of that nature. But I think it's important, again, that we continue to have the conversation so that we can support safe access to medical cannabis, so that the regulations are in place, so that we can ensure that qualified patients can get to it. I will tell you that I did prosecute a home invasion robbery case when I was up in Mendo, and what they were there to steal was marijuana. And the individual was growing, so he said, for a collective. And it was interesting in the process of jury selection to ask them how they felt about that, since the victim was perhaps considered to be somebody engaged in the illegal conduct. Well, they convicted, and the man is looking at almost 90 years. So the public gets it. Nobody wants violence in our community under any circumstances, and that's what I want to help to protect against by making sure that we have safe access to medical cannabis and that it's well regulated. Thank you.
Stefan, same question.
Well, first of all, 8 years ago and 4 years ago, I made it very clear that we were not going to waste taxpayers' money on having jury trials on medical marijuana if they were qualified patients, if there was legitimate use or legitimate qualified caregivers, and we haven't done that. I've kept my promise. Our focus under my leadership has been to be tough on violent gang members and sexual predators and really strengthen our crime prevention programs, and we've done that, and we've made sure that the voice of victims is heard. And that's why I have strong support from the Attorney General, the Sonoma County Law Enforcement Association, because crime is down in Sonoma County. From 2004 to 2008, there's been a 27% drop in violent crime alone in Santa Rosa. And there has, unfortunately, been some instances in Santa Rosa where a young man was murdered. A garage had some plants in it. Those plants were confiscated, and a young man was killed. So anytime there is marijuana associated with violence, we're going to continue being diligent in bringing people to justice. Anytime there's environmental damage, if you will, to our beautiful landscape here in Sonoma County, we're going to pursue that as well. Under my leadership, we've expanded our environmental unit to not only safeguard our natural resources, but ensure that it will be there for our children and our grandchildren in the future. In terms of prosecution, I think I mentioned at the outset, the guidelines we still use here in Sonoma County, the 30 plants in a 100-square-foot canopy and 3 pounds is still something that we're following. We've been following it irrespective of the Kelly decision. Sometimes, however, law enforcement will request that we go forward on cases, and we've had to say no. Where we feel we're going to give the benefit of the doubt to qualified patients. We've done it for 8 years. We're going to continue doing it. And, you know, what happens in November could turn everything upside down as well. So we'll just have to wait and see. But we have very experienced prosecutors handling these type of cases. 2 prosecutors are assigned to these type of cases, and they work very closely with law enforcement. And they'll continue to do so to ensure that we're being fair, that we're being compassionate, and that's what we've done, and we're going to continue doing it.
Thank you. Stefan, back to you. And this question involves return of property. In cases where, in medical cannabis cases, where there are initially charges, but those charges that have been filed are dismissed, and the patient seeks to have their medical cannabis returned, what will be the policy of your administration in that situation?
We've had a policy and practice for my tenure as district attorney. We're going to continue the same practice, and that is if there's a motion to return property, the practice has been that the custodian of the evidence and their city attorney or the county council handles that matter. We're not involved in that hearing. We're not involved in that process. For example, if it's the sheriff's office, and say, for example, we didn't even file charges. There's been cases where we did not file charges. A motion was made in front of a Superior Court judge, and the sheriff was represented by county council. So that practice has been in place. It has been followed. Sometimes it's frustrating for patients, for defendants, for defense attorneys, but that has been the practice that has been in our jurisdiction. Other counties might have different types of policies in that regard. But whether it's going to be returned or not is a decision by the judge, and whether county council opposes it or the city attorney opposes it, that is something that's done outside of our office. So, Joe, to be very candid, we're not involved in that process, and the county council has opposed the release of property on a number of occasions on the theory that it's a controlled substance, that the federal law precludes the law enforcement agency from returning that property. And there's been occasions where a judge has denied, actually there's been one particular occasion where a judge granted the return of property over county council's objections. And so that continues to be the practice. It's somewhat a gray area at times, because it seems that if I guess the other thing too is you know, obviously if the evidence has been in a locker or has been destroyed, which sometimes happens, then obviously there's a monetary issue. There's been lawsuits and there's been settlements by the county to provide fair compensation for the value of those plants.
Thank you. Mr. Abbott, same question.
Sure. This is a kind of a specific question because it says where charges are filed and dismissed and the patient seeks their medical cannabis related in articles returned. So we're looking at cases that are actually filed and then dismissed. Obviously, if a case is never filed by the DA's office, the DA doesn't have any jurisdiction to object whatsoever. It's between the seizing agency and the individual who's trying to get their property back. So it would be between the sheriff or the other law enforcement agency and the individual. And generally, police officers are represented by attorneys, like a lot of people. And so their attorney would deal with whether or not the property would be returned. If it was pursuant to a warrant, then they would go to the judge because it was seized through authority of the court, and then the court would have to release the materials. If the case has been filed and a disposition has been reached, that means you've done something short of dismissal. Then the DA retains jurisdiction with regard to whatever's been seized. And From experience, I can say that sometimes a disposition will be reached in exchange for forfeiture of the marijuana, or forfeiture of the marijuana above the guideline limit, or forfeiture of the growing equipment, depending upon the nature of the offense and the disposition reached. But if the case is filed, then the DA is out of the case and no longer an interested party, and it's up to the seizing agency to take whatever measures they want to take with regard to the return of the property. If it's ever under the jurisdiction of the district attorney's office, of course, we'll object to the return of contraband if it's found to have been contraband used for a criminal enterprise. And with regard to firearms, as everybody knows, you're going to have to show proof of ownership and proper registration before you can get those weapons back. Again, it's a public safety issue, but really this question goes more to how law enforcement agencies are going to respond to the request, and less to how the district attorney's office is going to weigh in. I will tell you, in speaking with law enforcement, specifically narcotics officers, it's not unusual for them to see growing equipment returned to a legitimate cannabis patient. So I don't know that here the sheriff's office is objecting strenuously to the return of property in cases that are either not filed or where charges are dismissed. That's just based on the information that I've been receiving in speaking with individuals involved.
Thank you. And just one clarification on a follow-up. Will your administration, if you are elected, be instructed, will deputies in your administration be instructed to include in their plea deals that property should be forfeited in exchange for the plea?
I won't direct them to do that. I have issues with directing deputies on a uniform level what they should and should not do. I think every case stands on its own. You have to look at the facts of the case, the individuals involved. I think that the deputy DAs are trained to use their best judgment and experience. You want to have experienced lawyers dealing with these kinds of cases. So I will not set a policy with regards to the return of property. However, I will tell you that philosophically, the return of contraband is something that I object to. If something's been used in a criminal enterprise, then I don't think that the individual who used it should be entitled to its return. But that's different than somebody who is a legitimate patient who had their supplies taken from them. And that's really what we're here to talk about, is protecting your rights. And I'm all for protecting your rights. As long as you do it the right way, I'm behind you 100%.
Thank you. Stephen, same follow-up question.
I thought I answered that question. Could you repeat the follow-up then?
The follow-up is that well, deputies in your administration, you mentioned that there are 2 deputies, deputy DAs that prosecute marijuana cases. Will those deputies be instructed to demand forfeiture of medical cannabis in cases where there is a negotiated resolution or a plea deal?
We have a assistant district attorney, 2 assistant district attorneys who are here tonight. Diana Gomez, a very experienced prosecutor who came here from Orange County, who oversees that aspect of the criminal division. We also have assistant district attorney Christine Cook, who handles special operations, and they oversee these particular issues. But we try to have uniformity and consistency as to how we render justice. We don't say one attorney can do it this way today and tomorrow another attorney can do it a different way, because that's unfair to the defendant, that's unfair to victims, and so we have consistency, and the policy of that unit is to be fair and consistent on how they resolve cases. So it would depend on the specific circumstances of the case. It would depend on a number of factors. Were there weapons involved? What type of enterprise was this? Was this a gang member? We've had cases involving gang members with marijuana. So there's a number of factors, and you can't really have a specific cookie cutter type policy on a matter like this because there's so many factors that play into it. But one of the things I can tell you we've done and will continue to do is be consistent and fair in this area.
Thank you. And Jill, back to you. Currently, the Sonoma County Medical Cannabis Dispensary Ordinance is being challenged in civil court, and I believe there was some mention of that, a ruling earlier in a conversation about that. In the meantime, Sonoma County is not accepting dispensary applications. The question is, what are your thoughts on how to be compliant with state and local laws as a storefront provider of medical cannabis in Sonoma County?
Okay, I'm going to tell you the truth. When I read this, you know what my first response was? It was to write U-G-H, UGH. It's a hard area. This is a very difficult area. And as I understand it, and I mentioned earlier, Judge Boyd has granted a preliminary injunction against the county with regard to Marvin's Gardens. I've not read anything about it. I've just been given that information. And basically, my understanding is the ordinance has been invalidated until there's further ruling by the court. So we're kind of in a position of flux. I don't really want to make a representation of how I'm going to proceed or how things should proceed, because between our conversation tonight and January, when I would take office if I'm elected, there's going to be a ruling in this case, and it's going to have a wide-ranging impact right here in our community. So I think it's important that we watch this as it moves through the court. It's going to speak volumes to us with regard to dispensaries. We have dispensaries that are operating right now, and I think we should continue the dialogue and continue to understand what the problems are with the application of the ordinance, as well as the permitting process, and maybe use this period more for dialogue and figuring out how to go forward and wait and see what the final ruling is in this particular case. I suggested to somebody I spoke to earlier that we should just take a step back and wait and see, and he said, no, you need to be proactive. You need to tell people what you're going to do. Well, respectfully, I don't know. I really don't. I'd like to read the opinion. I'd like to take a better look at it. I've only recently read the ordinance, and I think it's important that before you take a position, you be well-versed in the area and that you have a complete understanding of what's going on, and I think that's true for all of us. This is cutting-edge stuff here. And I think it's important that we move slowly and carefully and make sure that we're taking all the right steps so that at the end of the day, when dispensaries are set up, they're done it properly so that they don't have to risk having law enforcement coming in and shutting them down and the possibility of prosecution because they're being run illegally. So that's really the only answer that I can give at this point, just a willingness to continue to dialogue and educate ourselves about the issues.
Thank you. Stefan, same question.
Obviously, as the district attorney, I know many of you would like me to provide you legal advice. Unfortunately, my ethic parameters do not allow me to provide legal advice as if you were my client. So I'm not going to do that tonight, but I would make a suggestion that if you are going to have a storefront business, that you really have a good civil attorney. There's one here in the front row who knows this area inside and out, but it really comes down to understanding the zoning laws, understanding the planning process. Just for example, if there's a liquor store, where is a city council or a county with respect to their general plan, going to allow that liquor store to be located? Obviously, they're not going to allow it next to a school. They're not going to allow it next to a hospital or a doctor's office. So I think the present law involving the lawsuit, it's a civil lawsuit, by the way, with Marvin's Garden, and there's supposed to be a decision that's going to be released in the near future. But I think the whole process and the message is that you can't just open up a dispensary. You have to go through a lengthy process. There's attorneys locally and statewide that specialize in that process to go through the planning department, to go through the various city councils who ultimately can make some of those decisions if they're challenged locally. So I would just say that it's also important to be a community partner on those issues. I think as the county, as the community is more acceptive of storefront businesses and medical marijuana, there's obligations on all business to be more involved in the community, and I think that is certainly a factor in this arena in terms of fairness. But at the end of the day, a city council or a county is going to do what's right for the safety of their community, and they're not going to allow dispensaries or too many dispensaries that may have a negative impact on the community in terms of, especially if they're not structured in a way that is safe, secure. And it may be that the ordinance at some point has changed to have some of the language and the recommendations that's in Netherlands. How many people are familiar with the Checkpoint coffee shop in the Netherlands? Raise your hand. There's a few people here that maybe know about that. But what they did there is they had 440 pounds in the coffee storefront business. That's a lot of pounds. I guess that clap is applauding that. But they had 3,000 customers on a daily basis going there. A lot came from across the country, across the country lines in Belgium. But the point being is the court there rendered a decision that there were certain elements to that amount of marijuana in that store. And so that's something that I think would have to be looked at here.
Thank you. Thank you. Now moving on to another topic, and this question is back to you, Stefan. This has to do with the November ballot initiative. I think there's actually 2 authors of that initiative in the room tonight. And essentially there is, it's been confirmed that there's enough signatures been collected to put a tax and regulate cannabis initiative on the November ballot in California. Assuming that the measure passes and California legalizes cannabis, what policies do you anticipate for medical cannabis patients, and what policies will need to be reconsidered in the district attorney's office?
Well, first of all, I think, are there a couple authors and proponents here tonight? Is there an author here by chance of the ballot?
There's 2 co-authors. I'm one of them.
Okay. Joe? Well, having said that, I think first I would say that the proponents certainly had good intentions with the initiative. But I think there are some unintended consequences in terms of public safety, in terms of how it would be regulated. Because the fact of the matter is, the initiative does not have a statewide regulatory scheme or process. It says regulations would be delegated to local governments. It also has something in there that maybe most people are not aware of. It would prohibit employers from receiving federal funds pursuant to the Drug-Free Work Act. Because an employer that is receiving a grant over $100,000 would have to certify that it's a drug-free environment in the workplace. And that would be problematic and could jeopardize many businesses from receiving federal grants. But in the perfect world, if this did pass, and there's a likelihood that it may pass here in California, it's going to completely change and turn upside down the whole law enforcement and prosecution arena. We won't be prosecuting these cases unless there's really some egregious aspect involving weapons and selling it in a manner that is not permissible. But it does make it pretty clear that the laws would be null and void in terms of possession of marijuana. Obviously, it has an age restriction, 21 or older, just like alcohol. And we would prosecute those like we do right now for alcohol if they're impaired. And we have prosecuted people who've used drugs and a combination of alcohol. We had a case here in Sonoma County where a young man was driving with marijuana in his system and cocaine in his system and killed a family of 5 on Highway 101. So it's clear that drugs have to be used in a responsible manner, and we'll continue to ensure that is the case. I've done that during my tenure. I've kept my word to you in that regard. But it is somewhat, there's some vagueness in the initiative that may present some problems down the road, and I think Joe did a fantastic job of getting the signatures and putting it on the ballot, because the voters should decide whether marijuana should be legal here in California.
Thank you. Jill, same question.
Kind of dicey to ask us this question with you standing there, Joe.
It's a long story. I don't know.
Got it. Okay. Well, I think there are going to be a lot of ramifications that we're not going to know until it goes into effect. One of my concerns about the Compassionate Use Act and the Medical Marijuana Patients Act that went into effect is we never really saw a lot of discussion about distribution of medical cannabis, and now we have this vague area that we're dealing with regard to dispensaries, collectives, and cooperatives. I am concerned that we're going to have vagaries, with all due respect, Joe, in regards to this initiative as well. It does seem to me that the title couldn't have been better, the Regulate, Control, and Tax Cannabis Act. If they'd have made tax a little bit bigger, you probably would have been guaranteed that it would pass in November. I think everybody agrees that marijuana is not going to go away, and people are starting to be smart about addressing whether or not it's time to regulate it, control it, and tax it. As a law enforcement official, I'm not going to tell you whether or not I support this, but I anticipate that we're going to have a lot more resources available to pursue violent offenders in our community, because a lot of resources are being expended right now to enforce marijuana possession laws. So I can see a real shift in terms of where law enforcement directs its effort if this passes. But I also anticipate there's going to be a lot of litigation in the event this initiative passes as well, and we're going to have to sort of follow along and see how it goes. But I think it will be a dramatic shift with regard to law enforcement. It will definitely require law enforcement agencies to take another look at where they're directing their energies and how they're going to go about their practice. But remember, even if this initiative passes and becomes law in November, we're still up against the federal law. And I think that everybody needs to be very vigilant in terms of their approach to not only medical cannabis, but also to this initiative if it passes. Because California can do one thing, but it isn't as goes California goes the federal authorities. So I suggest that we approach all of this with due care and due caution, make sure that we're working together in a well-regulated environment to ensure safe access, but that we not jump the gun, with all due respect, Joe, and assume that pretty soon here marijuana is going to become legal across the board, and we're going to have taxes to put into our schools and educate our kids, which of course is a great idea. So I can't really say much more about that. It's kind of we're going to have to see what happens. But I do think it's going to allow both the DA's office and other law enforcement agencies really to reprioritize our resources. Thank you.
Thank you. So that concludes the preset 6-question portion of the event. Now we're moving on to the questions from the audience. Each candidate will have 2 minutes to respond to each question. And the first one is just a follow-up off of the former question. And this is going to go back to you, Jill. In follow-up, the initiative contains language that would create a so-called wet and dry county system, similar to what exists for alcohol in the South. In the event that this initiative passes, would you support Sonoma County being a wet county?
I don't understand that question.
Okay.
I'm sorry.
Yeah, I'm sorry. So in the language in the initiative, there would be a wet and dry county model. And essentially what that means is distribution would be permitted only in the event that a local jurisdiction implements an ordinance to allow that distribution, or commercial cultivation, sales, transportation, processing, things of that nature. So my question is, in the event that the initiative passes, would you support Sonoma County being one of those counties that fully implements the act and would be a so-called wet county?
You know what, I have to tell you, with all due respect, I think that if I answer that question, then I'm suggesting to you what my position is on the initiative. I really do. And I apologize if you think I'm dodging the question. But I really feel that given where I am right now as a candidate for district attorney, I just don't feel right sharing my personal opinion on this particular subject with you at this time. All I can tell you is whatever the decision of the voters is in November, I will certainly do everything I can to ensure that whatever the outcome occurs, people's rights are protected, laws are enforced, and that our community is as safe as it can be. But respectfully, I just don't think that's something I should answer at this time. I'm sorry.
Thank you. Stefan, same question.
Well, I certainly understand the question, but I think that one of the challenges with this initiative, it gives the impression that it's going to solve the state's budget problems. And I think that's a pretty big wish, because the fact of the matter is it leaves to local jurisdictions how they're going to regulate it. And so that means that city councils or counties or the state legislature would have to enact a law regarding the taxation, which is a whole other process in and of itself. But with respect to the parameters that Joe alluded to, I'm not a politician. I'm not a legislature. I would not be writing the laws in that regard. I don't know the specifics there, so I wouldn't be able to shed any more light on it than my opponent. I guess we agreed on something there. So, Joe, I'm going to turn it back to you.
Oh, thank you. Thank you. And
Can we mark the tape? We agreed?
okay, Stefan, this question is going back to you. If reelected, do you believe that medical marijuana prosecutions will increase or decrease?
You still got your quarter? Yeah. That's hard to say, quite frankly. You never know what's going to come in the courthouse. You never know what is going to occur in the community. But I can say this, is under my tenure, we have not had jury trials on medical marijuana. I think that speaks volumes in terms of being fair, listening to the defense attorneys. Yes, we do listen to the defense attorneys. I see a few here in the audience here today. So it just depends on the climate, it depends what's going on. But I think the dialogue we've had for the last 8 years has really benefited the community with representatives of SAM, representatives of Americans for Safe Access, the law enforcement community. We had this conversation a long time ago. In fact, when I was elected president of the Sonoma County Chiefs Association, we had numerous conversations and dialogues about how we could work together for the benefit of qualified patients. And I've been told tonight, and I was told earlier this week, that Sonoma County has one of the most reasonable and fairest processes to help qualified patients, and I'm proud of that.
Thank you. Jill, same question.
And the question was whether prosecution would increase?
Yeah, the question is, if elected, do you believe that medical marijuana-related prosecutions would likely increase or decrease?
Well, I don't know why they would increase, and if, as is represented, there aren't any, I don't know how they could decrease. But again, medical marijuana prosecutions, qualified patients should be guaranteed safe access in a good, regulated manner. If we carry out those goals, there shouldn't be any prosecution of qualified patients. It's the people that take advantage of the rules that are going to be subject to prosecution, because they're going to be taking advantage of what you all have worked so hard to come up with. And when you talk about people working well in the community, I mean, I've talked with people like Kumari and Mary Pat and so many others of you, and I think that respectfully, there needs to be better communication from the district attorney's office from the information that I've received. And I'm all about good communication. I'm all about good discussion. And I think that if we continue to do that, we will definitely ensure that this zero level of prosecution will continue. Because I don't want to trample on your rights. You follow the rules. I respect that. It's the people who don't follow the rules that we need to hold accountable. Thank you.
Thank you. And just a clarification, is currently, Stefan, this question is directed towards you. Currently, is there zero prosecutions for medical cannabis cases, or has there been zero jury trials?
Well, I think you got to look at the lay of the land. When law enforcement makes arrest, if there's no documentation that the suspect is a qualified patient or a caregiver has the appropriate documentation, and it's not forthcoming in a short time frame, then we do file charges, because again, it goes back to whether there's legitimate use of medical marijuana. We've held off on filing charges on occasions to get that documentation and have not file charges on those cases. But many times, I've talked to some people here tonight, one of the things that we would like to streamline is that process, because many situations develop where at a later date, we do receive documentation where we feel we would not be able to proceed at trial. The case gets resolved or the case gets dismissed, and that really is not a effective use of resources. So we could make some improvements in that area, and that I think, given the conversation I've had with people in recent days and weeks, it may be time for bringing a committee together to have a conversation about how we can be more effective in streamlining that process. But I guess what I would say, Joe, is we haven't had any trials, unlike other counties in the state. In fact, there was cases in San Diego, LA, and other nearby counties where they've gone to trial and juries have not reached a guilty verdict, or where there's been acquittals. And that has simply been, in my opinion, a waste of taxpayers' money. But we do have cases in the courthouse where there's not been documentation showing that it is a legitimate medical marijuana. So we're going to continue in that regard. But if we, if there could be better coordination with patients and caregivers and with law enforcement, then we wouldn't have to file any of these cases. And that's something I think we should all strive to do.
Thank you. The next question goes back to you, Jill. And this question concerns lawful collectives. Oftentimes, a lawful medical cannabis collective, there will be present what's called indicia. And as a prosecutor, I'm sure each of you know what indicia is. And those are items which tend to show that something is unlawful, possessed for sale, such as scales, packaging material, the cannabis itself, money, etc. When those items are present, how would you differentiate a lawful collective from an unlawful collective?
Okay, that was kind of a tricky question because it began with, in a lawful collective, there might be indicia. So the question kind of began with a presumption it was a lawful collective. I think that where law enforcement gets involved with collectives is whether indeed they are lawful. And again, this is an area of the law that's very sketchy. It says there can be reasonable fees received in exchange for the cultivation and sale of the product to the collective of which you're a member, and that the individuals, if it's a dispensary who are running it, are entitled to reasonable fees. And some of the items that you mentioned, I would imagine, are tools of the trade. I mean, you need scales and things of that nature in order to put the product out for purposes of the patients getting it. But if somebody is operating a storefront facility for financial profit and is not making efforts to work as a lawful collective, I mean, we've worked hard to be able to establish the whole notion of collectives in this county and in this state. So there are those that will be profiteers. And if it looks like somebody is simply hiding behind the notion of a collective to run an illegal business and there's sufficient evidence to support that, then yeah, we'll look at prosecuting it, absolutely, because these are people that will be taking advantage of the rights that you have worked so hard to receive and the protections you've worked so hard to get. And unfortunately, there are those that will take advantage of the situation, and if they do, then they should be held accountable so that you will be able to continue engaging in lawful conduct.
Thank you. Stefan, same question.
During my tenure as DA, we have not had any volume of cases or any cases I'm really aware of that we've gone after a collective for operating illegally. In fact, law enforcement has not brought up any significant case saying that we should go after a collective or close down a collective because of a criminal enterprise. Now, the DEA might have a different opinion, but we are not involved in that process. So I think the indicia that one would look at, hypothetically speaking, that is if the person is, because it does say that they can have the guidelines from the Attorney General, just to quote this one area, talks about a collective should be an organization that merely facilitates the collaborative efforts of patient and caregiver members, including the allocation of costs and revenues. Now, let's say a person opens up a storefront collective and all of a sudden is, after maybe 6 months after opening it up, is driving a 2010 740i BMW all of a sudden has a new home that's purchased, and all of a sudden has a house in Tahoe and a house in, let's say, New York City, then that type of indicia may suggest that there is some type of criminal enterprise going on that the federal government may look at, but we certainly don't have the resources, and we're not going to go after that type of enterprise, because our main priority is going after violent gang members and sexual predators, protecting our children, and making sure that we do everything we can to prevent crime. That's why I'm so proud of our the relationships we build with the Boys and Girls Club to keep kids out of gangs, the relationships we build with the Council on Aging and senior advocacy to put on forums to give information to seniors so they can defend themselves from the con artists that commit scams and take advantage of the elderly in our community. We're going to continue utilizing our resources in that way, which benefits the overall well-being of our community.
Thank you. Next question. Stephan, this one is back to you. The District Attorney's Office is part of the executive branch of government. With the voters, the legislature, and the judiciary all interpreting broad rights for persons protected by California's medical cannabis laws, what role do you believe the executive branch has in either affirming or challenging those protections?
That's a pretty big question, open-ended question there, Joe. Do you have any specific examples?
Well, for example, do you believe that it is within the purview of the District Attorney's Office that your office would challenge some of the standards already set forth by the legislature or the judiciary?
Again, without looking at it kind of in a vacuum as we are right now, it's difficult to say, depending on what the specific case was or what the specific law was. But in terms of medical marijuana, we have not challenged the law in that regard in Sonoma County. We will not continue the law for medical marijuana in Sonoma County in the next 4 years if the voters so kindly grant me a third term. So we're going to continue being fair and not really upset the apple cart, if you will, in terms of doing something that's unfair to patients' rights, and we're going to continue respecting patients' rights and ensuring that qualified patients get the medicine they need to take care of their particular illness, whether it's cancer or some other type of health concern.
Thank you. Jill, same question.
The district attorney's job is to enforce the laws. It isn't really to challenge the laws. That's up to you, the voters. It's up to the legislators to change the laws. The DA's office enforces the laws, and currently the laws protect qualified patients who are seeking medical cannabis. So that would be a law that I would enforce, and it would be an easy law to enforce because I believe it, I support it. I think it's the right thing. And so I don't anticipate that there would be any challenge to that. It's kind of a, would you like some water? Okay. We have a little bit left. Been drinking a lot up here. But it's kind of a vague question to ask that as a member of the executive branch whether we would challenge it. Now, there may be rulings that will challenge, depending upon how courts rule on cases that come into court. For instance, if there is a case that comes into court involving somebody who is not a qualified patient, who's taking advantage of the laws, or somebody who's not a collective, but again, taking advantage of the laws for criminal profiteering. And if there's a court ruling that's adverse, we may challenge that ruling. But that's a little bit different, I think, than the question that was asked with regard to advocacy. So the only advocacy I anticipate if I'm elected is advocating for enforcement of these laws and working together to make sure that these laws protect your rights. Thank you.
Thank you. We only have a few minutes left, so I'm going to ask a couple of questions fairly briefly. And Jill, this one is back to you. Do you believe that patients give up their Second Amendment rights once they become medical marijuana patients? In other words, is someone's Second Amendment rights mutually exclusive with their state right to have and obtain medical marijuana?
Well, you know, it's hard because there is such a conflict between what the federal rules are and what the state rules are, So I don't think, it's kind of a hard question to answer. I don't think you give up your constitutional rights by being a medical marijuana patient, if that's what your question is. Is that what you're alluding to?
That's what my question is. So in other words, in a circumstance where there is a medical cannabis patient, there's medical marijuana present, yet there's also a lawful firearm, do you believe that there's illegality there? Is it those rights mutually exclusive with one another?
Well, if it's a legally possessed firearm, I don't think so. I mean, and if it's a legally possessed amount of cannabis because it's a qualified patient, I don't think so. I don't think you just do a knee-jerk reaction and say there's marijuana and there's a gun, therefore it's an illegal enterprise. You got to take a look at everything. A lot of people are entitled to possess firearms in a legal manner, and just because you're a qualified patient and happen to have a firearm, hopefully in a gun safe, or some other safe place, I don't think that immediately imposes some sort of criminal liability on you. That would be contradictory.
Thank you. Stefan, same question.
Well, first of all, I certainly support the right to bear arms, and that constitutional right like that certainly should not be given up just because someone is a qualified patient. So I think that's a pretty simplistic question, a pretty straightforward question that they're exclusive type rights. A person has a right to have medical marijuana if they qualify, if they have an ID card, or if they have a doctor's recommendation for a particular illness or ailment, if you will. So I think they are rights that need to be protected on both levels, and I think we strive to do that. Thank you. A little tongue slip there. We strive to do that on a regular basis, and we'll continue to do that in a fair manner.
Thank you. Thank you. And very quickly, there's only a couple of minutes left. So, Stefan, back to you real quick. What is your expectation of parents who are lawful medical cannabis patients and the relationship of that cannabis to their children? What is your expectation of them?
When I first heard that expectation of parents, he really got my attention because I'm the father of 2 little girls. And the other day we were riding down the road, and my daughter said, my 5-year-old said, "Daddy, there's a Paso Aqua sign." And she goes, "Do more Paso Aquas live there?" And I said, "No, there's an election coming up, and people are going to vote whether your daddy's going to keep his job." And she goes, "Vote Paso Aqua, vote Paso Aqua." In any event, I think parents have an obligation to ensure that there is fairness, that their children are using things in a responsible manner, whether it's alcohol. I mean, if a kid is 15, 16 and they're drinking alcohol, the parents should take appropriate steps. And the same thing with marijuana or any other drug, unless there's some type of they become a qualified patient because of an illness. And obviously there's children, sad to say, that do have cancer. They are dealing with radiation and effects of radiation and chemotherapy. So in that type of situation, I think a parent has an obligation to make sure that a child has the best medicine that's going to help them in that situation. And Dr. Abrams from San Francisco General Hospital has made it very clear that, in his opinion, medical marijuana is one of the most effective medicines to help people who are dealing with radiation and chemotherapy. So I think the responsibility is for parents to learn not only about the consequences of alcohol and drug, but if it's medical marijuana, find out what works the best. And I know there's some patients here in this room that have tried different types of medications for cancer, and medicinal marijuana was the best choice to help them deal with the effects of the treatment they were receiving for cancer.
Thank you. Jill, same question.
And I got a little bit lost there. Is the question, well, what is the question?
The question is, if you're elected, what is your expectation of parents who both are medical cannabis patients and have children around their medicine. What is your expectation of those parents as
Okay.
district attorney?
Okay, yeah, I wasn't sure. I was just at a child abuse prevention luncheon this afternoon, and I just heard powerful information from one of the speakers about kids and how they're impacted by their social setting and what that can do to them later on in terms of their sort of relationship with others. I think it's really important that we protect our kids because sometimes they're in a setting where they can't protect themselves. I think we should hold parents accountable if they put their kids in an endangered environment. I like to believe that medical